My name is Jennifer Lorenz, and I am going to ask that we hold all questions until the end. I have quite a few slides to go through. We're going to be discussing the two new updates to employment law that went into effect this year. And I'm sure most of you recall, last year, 2020, the Families First Coronavirus Response Act was signed on March 18th, 2020, and that created emergency paid sick leave and emergency family medical act leave. And it was applicable for employees working for private sector employers with fewer than 500 employees. That act took effect on April 2nd of 2020, and it ended on December 31st, 2020. The Consolidated Appropriations Act of 2021 has extended employer tax credits for paid sick leave and expanded Family Medical Leave Act voluntarily provided to employees until March 31st, 2021. However, the CAA did not extend employees' entitlements to sick leave under the Emergency Paid Sick Leave Act or Emergency FMLA through December 31st. So it is done, it is ended. So our 2021 updates. On July 14th, 2020, Governor Polis signed the Healthy Families and Workplaces Act into effect. And that can be found now at CRS 813.3.401. The new law has two primary major components. The first component can be found at 813.3403 and requires employers to provide paid sick leave to employees under certain circumstances that are defined or found in the Act. The second component can be found at CRS 813.3405 and addresses paid sick leave or emergency paid sick leave during pandemics. So this second component is designed for the long term, and it's not limited to just this current COVID-19 pandemic. The act went into effect on January 1, 2021 for all employers with more than 16 employees, and it will apply to all employers regardless of size effective January 1, 2022. So, the act can be found at 813.3403, and it applies to all employees working in Colorado. So the act provides us with numerous definitions, including who is an employee under the act. And employee has the same meaning as set forth in the Colorado Wage Act. Employee, as defined under the Colorado Wage Act, means any person, including a migratory laborer, performing labor or services for the benefit of an employer. And relevant factors that are, of course, taken into consideration in determining whether a person is an employee include the degree of control the employer has or exercises over the person and the degree to which the person performs work that is primary work of the employer. Of course, employee does not include independent contractors, and this act specifically excludes employees who are covered under the Railroad Unemployment Insurance Act. So railroad workers are not included. So the act defines employer to, of course, have the same meaning as set forth in the Colorado Wage Act, and employer is defined under the Colorado Wage Act to be consistent with the definition provided under the Fair Labor Standards Act. And that includes a foreign labor contractor and a migratory field labor contractor or crew leader. But what's also included here is that states or its agencies or entities, counties, cities, municipalities, corporations, quasi-municipal corporations, school districts, irrigation districts, reservoirs, and drainage conservation companies are included as well, but employer does not include the federal government. So states included, federal government not included. So the real meat of the act, or at least of the first component of the act, provides for sick leave accrual and carry forward of paid sick leave into the subsequent year. So each employee earns at least 1 hour of paid sick leave for every 30 hours worked by the employee. An employee is not entitled to earn or use more than 48 hours of paid sick leave each year unless the employer selects a higher limit, and the employer can select a higher limit. An employer can satisfy the accrual requirements provided for under the Act by providing the employee with an amount of paid sick leave that meets or exceeds the Act's requirements at the beginning of the year. Nothing discourages or prohibits an employer from providing paid sick leave that accrues at a faster or more generous rate. An employee who is overtime exempt accrues paid sick leave based on the assumption that the employee works a 40-hour work week. If the employee's normal work week consists of fewer than 40 hours, the employee accrues paid sick leave based upon the number of hours that actually comprise the employee's normal work week. Accrual begins at the start of employment, and sick leave can be used immediately. With employers, they have the ability to loan paid sick leave to an employee, even if they haven't accrued enough hours to actually take leave yet. So like I mentioned, paid sick leave does carry forward. An employee begins to accrue paid sick leave when they begin employment, and they can use it as it's accrued up to 48 hours of paid sick leave that an employee accrues in a year, up to 48 hours of paid sick leave that an employee accrues in a year, but does not use, carries forward, and then can be used the subsequent year. So if an employee doesn't use their entire 48 hours, the remainder can carry forward into the subsequent year. But the employer is not required to allow the employee to use more than 48 hours of paid sick leave in a year. So the employer can cap the accrual at 48 hours, regardless of whether or not there's carryover time. So employees must use their accrued sick leave in hourly increments unless the employer actually allows them to use smaller increments. And we're talking about, carry forward into a year. A year means a regular or consecutive 12-month period, and that's determined by the employer. Employers may offer a more generous paid leave policy so long as it allows the employee to use paid leave for the same purposes and under the same conditions as those applied to paid sick leave. An employer does not need to reimburse accrued sick leave after an employee's termination, resignation, retirement, or separation. So unlike paid vacation time under the Colorado Wage Act, sick leave does not need to be paid out at separation, or I guess I should say sick leave under this act does not need to be paid out at separation. However, if an employee separates their employment and then, so if an employee quits, is fired, leaves for whatever reason, and is then rehired by the same employer within 6 months after their original separation, the employer has to reinstate any paid sick leave that the employee had accrued but did not use during their previous term of employment. If an employee is transferred to a different division within the company, a different entity that may be wholly owned by the company, or a different location, but is essentially still employed by the same employer, the employee is entitled to all paid sick leave that was accrued prior to the division or entity separation or relocation, whatever it may be. And if a successor employer succeeds an original employer, all employees of that original employer maintain their accrued but unused sick leave under the new acquisition. So paid sick leave means time off from work that is compensated at the same hourly rate or salary and with the same benefits, including healthcare benefits, as the employee normally earns during hours worked. So same hourly rate or salary does not include overtime, bonuses, or holiday pay. And for employees paid on a commission-only basis, same hourly rate or salary means a rate of no less than the applicable minimum wage. For employees paid an hourly, weekly, or monthly wage plus a commission basis, same hourly rate means the rate of pay equivalent to the employee's hourly, weekly, or monthly wage, or the applicable minimum wage, whichever is greater. So paid sick leave is considered wages as defined under the Colorado Wage Act. And wages under the Colorado Wage Act, of course, include earned, vested, and determinable wages, at which time such amount shall be payable to the employee. And that amount, as we all know under the Colorado Wage Act, includes bonuses or commissions earned for labor or services performed in accordance with the term of the employer's policies. Wages or compensation, of course, do not include severance pay. So even though the paid sick leave is considered wages, it's not paid out at separation. So employees are entitled to paid sick leave in a broad range of circumstances and situations and may request leave orally, in writing, electronically, or via any other means acceptable by their employer. Employees can use accrued leave when a mental or physical illness, injury, or other health condition prevents them from working, or to obtain a medical diagnosis, care, or treatment, as well as preventative medical care. Employees can use sick leave to care for a family member with a mental or physical illness, or to help a family member get medical services. Sick leave must be allowed when an employee or an employee's family member has been the victim of domestic abuse, sexual assault, or harassment. And in those situations, sick leave may be used to seek medical attention, legal services or legal services for a victim, or mental health counseling, and also includes relocation. So if that person is seeking to relocate, the efforts they have to take to do so are also covered. In addition, sick leave can be used when a public health emergency closes an employer's work or school or their childcare facility, so their daycare, and an employee needs to find alternative childcare. So in that regard, it's really similar to what we had this past year under emergency FMLA and the CARES Act. So the last slide I just showed you detailed all of the basis for that leave in great detail. I know it's really small and hard to read, but it can be found under CRS 813.3404. So as you may recall, I just mentioned that the leave covers leave that's necessary for an employee's family member or to assist an employee's family member. And family member is defined as an employee's immediate family member. An immediate family member is defined in CRS 24401. And that also includes a child to whom the employee stands in loco parentis, or a person who stood in loco parentis to the employee when the employee was a minor. It also means a person for whom the employee is responsible for providing or arranging health or safety related care. So in this regard, family member, or the definition of family member, is pretty broad, and it's fairly consistent, like I said before, with the definition that was included in EFMLA and Emergency Paid Sick Leave Act. An employer cannot condition paid sick leave on disclosure of details related to an employee or the employee's family member's health information, or domestic violence, sexual assault, or harassment. So the employer cannot condition granting leave based upon disclosure of this confidential information. If an employee divulges health or safety details about themselves or their family member, this information must be kept confidential and stored in a file separate from their regular employee personnel file. I can't stress this enough, when we're actually going to go into more detail about this later, but confidentiality is really important. So how do employees, get paid sick leave? Like I said, their request cannot be conditioned on divulging specific information, but an employer shall allow an employee to use paid sick leave upon the employee's request, and the request can be orally, in writing, electronically, or by whatever other means the employer wants to accept. When possible, the employee should include the expected duration of their leave when possible. An employer may provide a written policy that contains reasonable procedures for the employee to provide notice when the use of paid sick leave is foreseeable. An employer cannot deny paid sick leave to the employee if they don't comply with a policy that the employer has in place. An employer cannot require, as a condition of providing paid sick leave, that an employee find a replacement worker to cover their shift or to cover their employment while they're out taking paid sick leave. And when paid sick leave is foreseeable, the employee has to make a good faith effort to provide notice of the need in advance, and they need to take a reasonable effort to use paid sick leave in a manner that is the least disruptive, or not disruptive to the employer. So they don't want the employee to unduly disrupt the employer if possible. So if the employee needs to take paid sick leave for 4 or more consecutive days, an employer can or may require reasonable documentation that the paid sick leave requested is for a purpose that's authorized under the act. But employers should be careful with that, because what constitutes reasonable documentation, considering the purposes that an employee can take paid sick leave, for example, sexual assault or abuse of the employer or their family member, gets into a confidentiality issue. So the employer has to be careful about what reasonable documentation they actually request or require. So now we move into the second part of the Healthy Families and Workplaces Act. And that is additional paid sick leave during a public health emergency. And this, of course, can be found under CRS 13.3405. So in addition to the paid sick leave provided under Section 403 that we just talked about, the Act also provides supplemental leave for public health emergencies. And public health emergencies are defined as an act of bioterrorism, a pandemic influenza, or an epidemic caused by a novel or highly fatal infectious agent for which an emergency is declared by a federal, state, or local public health agency, or a disaster emergency is declared by the government, or a highly infectious illness or agent with epidemic or pandemic potential for which a disaster emergency is declared by the governor. So in addition to the paid sick leave that we just looked at, on a date a public health emergency is declared, each employer in the state shall supplement each employee's accrued paid sick leave as necessary to ensure that an employee may take the following amounts of paid sick leave. So employees get what we're going to talk about next on the date a public emergency is declared. So for employees who normally work 40 or more hours, they get at least 80 hours. For employees who normally work fewer than 40 hours in a week, they get at least the greater of either the amount of time the employee is scheduled to work in a 14-day period, or the amount of time the employee actually works on average over a 14-day period. An employer cannot count an employee's unused accrued paid sick leave that we talked about before, the 48 hours under Section 4.0 leave, towards this supplement. So they can apply any unused but accrued sick leave that the employee has under Section 403 towards the potential total 80 hours that they get under this section. So it's my understanding that if the employee didn't take any paid sick leave under Section 403 and a pandemic is declared, they don't get 48 hours under Section 3 and then an additional 80 hours for emergency paid sick leave under this section, totaling 128 hours. The employee would get 48 hours under Section 403 and a supplemental 32 hours under this Section 5 to bring them to a total of 80 hours. And I would say check my math on that one. But I'm pretty sure that the total accrued amount is 80 hours, or the total available amount is 80 hours. And an employee may use this emergency paid sick leave until 4 weeks after the official termination or suspension of the public health emergency. So under, Section 405, this emergency paid sick leave section, an employer shall provide or must provide its employees emergency paid sick leave for the following reasons related to a public health emergency. And remember, this is all directly related back to the declaration of a public health emergency. And you can read the specific reasons here, but they include the employees need to self-isolate because of a diagnosis with an illness that's the cause of the public health emergency, self-isolation and care for oneself because the employee is experiencing symptoms of a illness that's cause of the public health emergency, to seek a medical diagnosis, for preventative care, and to do the same for a family member as well. An employee shall also notify the employee's employer of the need for paid sick leave as soon as practical when the need for paid sick leave is foreseeable and the employer's place of business has not been closed. Documentation is not required to take emergency paid sick leave. Employees are only eligible for paid sick leave once during the entire pandemic. So regardless of how many extensions there are to the pandemic, or if it's reinstated or prolonged for, like we're saying now, you only get to take this emergency paid sick leave under Section 405 one time. So, for example, if you get sick and then you have to take leave, and then your family member gets sick and you may potentially need to take leave again, you're only entitled to take leave under this act one time. I guess I shouldn't say only entitled to take leave. You're only entitled to paid leave under this section one time. So as we may expect, or at least I would say hope, you cannot retaliate against your employees for taking paid sick leave. Under the act, it's unlawful for an employer to count paid sick leave taken by an employee as an absence that may lead to or result in discipline, discharge, demotion, suspension, or any other retaliatory personnel action against the employee. These protections apply to any person taking leave under the act who, in good faith, alleges, I guess I should say, these protections apply to any person acting in good faith who alleges a violation of the act, even if it's determined that the employee was mistaken. So an employee is entitled to use paid sick leave consistent with the act, file a complaint or inform any person about an employer's alleged violation of the act, cooperate with the Department of Labor in its investigation of alleged violation of the act, and inform any person or persons about their potential rights under the act. An employer cannot take retaliatory personnel action or discriminate against an employee or former employee because that person has exercised or attempted to exercise or supported somebody else in exercising these rights. Retaliatory personnel action means the denial of any right guaranteed under the act, any adverse action against an employee for exercising any right guaranteed under this act, including any threat, discipline, discharge, suspension, demotion, reduction of hours, or reporting or threatening to report an employee's suspected citizenship or immigration status, or the suspected citizenship or immigration status of a family member of the employee to a federal, state, or local agency. It is unlawful for an employer to count paid sick leave taken by the employee as an absence that may lead to or result in discipline, discharge, demotion, suspension, or any other retaliatory personnel action. Violations of this provision and of this entire statute and act are investigated by the Department of Labor. So there are notification requirements, and I've provided links at the end to the Department of Labor posters that actually address these notice requirements for employees. So employers have to inform and notify employees of their rights under the act, and that they are entitled to paid sick leave, and the notice must specify the amount of paid sick leave to which employees are entitled and the terms of its use. And the notice or the posters also have to notify employees that employers cannot retaliate an employee for requesting or using paid sick leave, and that an employee has the right to file a complaint or bring a civil action if paid sick leave is denied by the employer retaliates against the employee for exercising their rights. An employer who willfully violates this section and the notice requirements is subject to a civil fine not to exceed $100 for each separate violation. If the employer doesn't maintain a physical workplace, which a lot of employers aren't anymore, or the employees telework, or they have teleworking employees who don't come into a physical workplace, the employer has to provide notice through electronic communications or a conspicuous posting on a web-based platform. So upon appropriate notice and at a mutually agreeable time, the employers must allow the Department of Labor to access records for purposes of monitoring compliance. And that's because employers are required to maintain records for each employee for 2-year period, documenting hours worked, paid sick leave accrued, and paid sick leave used. And like I just said, the Department of Labor can come in and audit the employer's records. If an issue arises as to the employee's right to paid sick leave and the employer has not maintained or retained adequate records, and the Department of Labor comes in and the employer is unable to provide adequate records, the employer shall be presumed to have violated this section 813-409, unless the employer demonstrates compliance by a preponderance of the evidence. So an aggrieved employee may commence a civil action in district court no later than 2 years after a violation occurs. Beginning January 1 of this year, an employer with 16 or more employees who violates the act, this entire act, is not this entire act, but the act is liable for back pay and any relief provided under CRS 85104, which includes reinstatement, promotions, pay increases, and liquidated damages, plus attorney's fees and costs. So before commencing any civil action, an aggrieved employee must submit a complaint to the Department of Labor and make a written demand for compensation or other relief to the employer. An employer then has 14 days to respond after receiving either a notice from the division or a written demand from the employee. And the aggrieved employee may demand a trial by jury. So like I mentioned before, confidentiality of employee information is incredibly important based upon the nature of the information being provided. An employer cannot require disclosure of details, like we mentioned before, relating to domestic violence, sexual assault, or stalking, or the details of an employee or their family members' health information as a condition of providing paid sick leave. Any health or safety information possessed by an employer regarding an employer or their family member must be maintained in a separate form and in a separate file from any other personnel information, be treated as confidential medical records, and not disclosed except to the affected employee or with the express permission of the affected employee. An infected employee, of course, means the employee whose health information it actually is, or the family member of the employee whose health information or other information it actually is. And information cannot be disclosed except to the affected employee or with the express written permission of the affected employee. So that was a general overview of the Healthy Families and Workplaces Act. So to recap, it includes two major components, paid sick leave and emergency paid sick leave in the event there is an epidemic or a pandemic. So the next new statute that went into effect this year, January 1, 2021, is the Equal Pay for Equal Work Act. And I think this is interesting because actually in May of 2019, Governor Polis signed the Equal Pay for Equal Work Act into law. It's just taking effect this year. The act was enacted to address pay disparities and is directed at preventing wage discrimination. So I'm going to give you, just so you know what we're talking about going forward, a broad overview of what the Equal Pay Act actually talks about or addresses. The Equal Pay Act prohibits employers from seeking prospective employees' wage rate histories. It allows employees subject to wage discrimination to file a civil action and provides for economic damages in the event of a violation, including, just like we saw with the last act, liquidated damages. The Equal Pay Act also contains several broader obligations and prohibitions intended to increase pay transparency. And those include requiring employers to announce opportunities for promotion or advancement, requiring employers to disclose hourly or salary compensation and benefits for each posting or job opening, and requiring employers to keep records of job descriptions and wage rate histories for its employees. The Equal Pay Act has the potential to impact employers nationwide. Even though this is a Colorado act, it has the potential to impact employers nationwide because its provisions cover all employers with at least one Colorado employee, and certain disclosures are required whether the relevant position is based in Colorado or another location. So under the Colorado Wage Act, wage discrimination is prohibited, and an employee cannot discriminate between employees on the basis of sex or on the basis of sex in combination with another protected status by paying an employee of one sex a wage rate less than the rate paid to an employee of a different sex for substantially similar work, regardless of job title, based on a composite of skill, effort, and responsibility, except where the employer demonstrates each of the following. And each of the following include, as are listed here on the slide, a seniority system, a merit system, a system that measures earnings by quality or quantity of production, geographic location, education, training, or experience to the extent that they are reasonably related to the work in question, or travel if that's a condition of employment. Each of these factors has to be relied upon reasonably. Each factor relied on must account for the entire wage rate differential, and that prior wage rate history was not relied on or justify, or I guess I should say, to justify a disparity in current wage rates. Independent contractors are not included, of course, in this analysis. And this is not any factor other than sex discrimination. As the statute says, each of these factors must account for the entire wage differential. So I went to the Colorado Bar Association CLE, I think it was maybe last week, and the entire CLE was dedicated just to this Equal Pay for Equal Work Act. And one of the questions that they were talking about during the CLE is whether or not the application of these factors is going to be a strict liability type claim, because each factor must be applied reasonably and account for the entire wage differential. So it's going to be really interesting to see how this is actually applied and enforced by the courts because of that language. Especially because each of these factors must account for the entire wage differential, and the employer must show that prior wage history wasn't relied on at all to justify the disparity. So this I think is going to be quite prevalent in the courts coming up here soon. So in a nutshell, the employer may not pay an employee of one sex a wage rate that is less than the rate paid to an employee of a different sex for substantially similar work. So substantially similar work is defined as a composite of skill, effort, including shift differentials, and responsibility, and job title is not indicative of substantially similar work. So job title alone doesn't mean much of anything. The determination of what constitutes substantially similar work is probably going to be a commonly disputed question. So wage rate includes hourly compensation plus the value of all other compensation and benefits. So what we were discussing before is that wage history. An employer cannot rely on an employee's previous wage history to justify some kind of pay differential. So an employer, cannot seek the wage rate history of a prospective employee or rely on the wage rate history of a prospective employee when determining that employee's wage rate. They cannot discriminate or retaliate against a prospective employee for failing to disclose the prospective employee's wage rate or history. And they can't discharge or discriminate or retaliate against an employee for invoking this section and the employee's new right not to disclose that information. This was, and I guess I should also add that they cannot discharge, discipline, discriminate against, coerce, intimidate, threaten, or interfere with an employee or other person because the employee or person inquired about, disclosed, compared, or otherwise discussed the employee's wage rate, with other people or with their coworkers. And that was, always prevented under the NLRB, but now it's actually prevented under this Colorado state statute as well, where there's now a private right of action to go along with any of this. So the employer also can't require an employee to sign a waiver or other document that prohibits the employee from disclosing wage rate information or that purports to deny the employee the right to disclose the employee's wage rate information. So if you're drafting employment agreements, it'll be important to keep these requirements in mind as well. So in addition to the pay disparity requirements under this Equal Pay for Equal Work Act, there are also new requirements that require employers to post promotions or job advancement opportunities, and those postings have very specific requirements. So employers must now post all known opportunities for promotions, and any postings for any job openings must include compensation and benefit information. Employers are required to make reasonable efforts to announce or post opportunities for promotions to all of their employees on the same day and before any promotion decisions are actually made. And they're also separately required to ensure that all job postings, both internal and external, disclose both hourly or salary compensation for the job, or a range of the hourly or salary compensation that would be provided. And they also have to post and include a general description of all benefits or other compensation to be offered. Violations of this notice requirement or these notice requirements can result in fines of $500 to $10,000 per violation. And this will be enforced by the Colorado Department of Labor and Employment. So those are some pretty darn hefty fines if they can be up to $10,000 per violation. Employers are required to keep records of job descriptions and wage rate histories for the duration of each employee's employment, so while the employee's still working for you, and for 2 years thereafter. And that's so that the Department of Labor and Employment or whoever else can determine if there is a pattern of wage discrepancy. So there's a 2-year period where you have to keep your employees' job description, wage rate histories, even after they leave. So you've got to post these promotional opportunities, like I just mentioned, and the postings actually have very specific requirements. And those requirements include that they be in writing, written or printed, so it reaches all employees. So it doesn't have to necessarily be printed because that might not be disseminated to all employees, especially in this remote work environment we have now, but it has to be in writing and in a format so that it reaches all employees. It's got to be delivered in a method that reaches all employees, and it goes to all employees for whom it may be a promotion. And it's got to go out on the same calendar day. And it's got to go out to not just employees that the employer believes are qualified for the position, but to all employees. The notice also has to be made sufficiently in advance of the selection or hiring decision, and that's so that the employees may apply for the position in a reasonable time frame so that the employee can apply for the position and actually be considered for the position. So the notice has to go out within enough time frame so that the employees can actually apply for it and be considered for the position. So in the notice, the written notice that's sent out to all your employees, you have to include the job title, rate of compensation or range thereof, including salary or hourly, if it's by piece or day rate compensation. You have to include the general description of any bonuses, commissions, or other forms of compensation that are being offered for the job. You have to give a general description of all employment benefits that the employer is offering for the position, including healthcare benefits, retirement benefits, and what days off you're permitted, including sick leave, maybe parental leave, additional paid time off, vacation benefits, and any other benefits that must be reported for federal tax purposes, but you don't have to include benefits that are in the form of minor perks. So, I mean, what minor perks look like? Maybe the cafeteria has Taco Tuesday or something. I have no idea. But minor perks that don't necessarily give rise to the level of the benefits we just discussed don't have to be disclosed. Or I guess I shouldn't say disclosed, but included in the notice. So there are specific exceptions to these posting requirements, and I'm going to hit them really, really generally and quickly because we are running out of time. Out-of-state postings, if there is absolutely no way that the job is related to Colorado in any way, shape, or form. So, you know, if it's for an auto mechanic in Iowa, not necessarily included. That would be an exception. I like this one. If you're replacing an existing employee who is unaware that they will be leaving and there are confidentiality concerns, then that's an exception. Temporary positions, those are an exception. Interns are an exception, and there are an additional list of exceptions that are provided for under the statute. But I think these are probably the biggest exceptions that you should be aware of that are accepted from the notice requirements. So a promotional opportunity. So you've got to post promotional opportunities. Well, what the heck's a promotional opportunity? Promotional opportunities exist when an employer has or anticipates a vacancy in an existing or new position that could be considered a promotion for one or more employees in terms of existing employees, of course, in terms of compensation, benefits, status, duties, or access to further advancements. So a vacancy exists when an employer backfills an existing position, adds a new position, or gives an existing employee a new position, including by changing their title or materially changing their authority, duties, or opportunities. Non-competitive inline lateral career advancements qualify as promotional opportunities because the company creates new positions or vacancies for the employees who are advancing or moving. And so Colorado employees must be provided notice of that opportunity. A vacancy is a promotional opportunity so long as the job is superior to another job held by at least one employee of the same employer in terms of compensation, benefits, status, duties, opportunities, or access to further career advancement. So if you have, you know, an executive or non-executive track, that would be further career advancement, or, you know, in the legal industry, partner or non-partner track. The promotion posting requirements do not apply to employees who are entirely outside of Colorado. So like I said before, if you're in Iowa and there's no way that there's any way that you could be in Colorado, doesn't apply. However, if a Colorado employer has a promotion opportunity available anywhere in the company, even outside of Colorado, Colorado employees must be notified. I think that's really interesting. So they have to be notified of the promotional opportunity. But at the same time, I think it may potentially come under an exemption as well. And I would love to hear other people's ideas about this after I'm done with this slide. So This is my last substantive slide. Oh, and I'm sorry, we're running late, but this is my last substantive slide. But under the Equal Pay for Equal Work Act, employers, of course, are liable if they violate this statute, and an employer who violates any provision is liable for legal and equitable relief, which may include employment reinstatement, promotion, pay increase, payment of lost wages, rates, and liquidated damages, and the employee's reasonable costs, including attorney's fees. So again, liquidated damages, just like we saw under the Healthy Families and Workplaces Act. Nothing in this section precludes an employee from also asserting additional available common law claims. The Equal Pay Act prohibits retaliation when an employee invokes the act and it prevents an employer's interference with or intimidation of any person who inquires about, discloses, compares, or discusses the wage rate of an employee. The provisions are designed to protect employees who discuss or compare wage rates in an effort to determine if unlawful disparities in pay exist. The Equal Pay Act applies to employers of all sizes. And there is a 1-year statute of limitation on notice and record keeping claims and 2-year statute of limitations for all other claims under this statute. So that's everything I have under the Equal Pay for Equal Work Act. These are additional helpful links that I mentioned before, including the notification posters that we've discussed. And now I'm gonna take it back to Kyle. I realize that we only have 2 minutes, but I think that the Equal Pay Act and the Healthy Families Act, you know, they're brand new. I think they are ripe for question and ripe for discussion. So if anybody has any questions or knows something that I didn't include, please, please speak up. And
this is Kyle. I was just going to say, if anyone does want to speak, you're able to unmute yourself either by pressing the space bar or going to the bottom left and just clicking on the little microphone icon. So there's not a red line through it. I didn't see any chat questions come in during the presentation. But again, you're able to unmute yourself at this point, and I'm sure if you have any questions like in an hour, if you wanted to send them to me, I can pass them along to Jennifer, and we can do our best to get those answered for you at a future point.
And Kyle's gonna send out the slides as well. At least I think he is, right, Kyle?
I am.
Okay, and in those slides, I have my contact information. If anybody has any questions or comments or anything else, feel free to give me a call, send me an email. I think that this is all developing and it's going to be interesting.
Those might be good words to end on, I think.
I think so. Well, thank you so much, everybody. I hope you're all doing well and staying healthy.
Yep, and I'll point out, I'm having a bit of a delay in getting the CLE forms from the Supreme Court. So I will send the Jennifer's PowerPoint today. And I'm trying to figure out when the CLE form is coming. I applied for it about a week and a half ago, which I thought was enough time, but apparently it isn't in this new paradigm. So I will send that along as soon as I receive it. And again, you'll have Jennifer's information and my information. So if you do have any further questions, you can contact us in the future. But thank you everyone for joining us, and thank you, Jennifer, for presenting today. Thank you, everyone. Have a good day. Bye.